Today, with the help of some actors, we're going to show you just what you can do about that lemon of a car.
For the first time in my life, I bought a new car. It was the greatest feeling. And then the problems began. Each time I've taken my new car into the dealership, the service people say they can't verify the problems. What can I do? I don't want to keep paying for a car that's a lemon.
If you buy or lease a new car and are repeatedly having trouble getting the problem fixed under the manufacturer's warranty, Hawaii's lemon law may be the solution to your problems. The lemon law can help you get a refund or a replacement car from the manufacturer. Under the law, the State Certified Arbitration Program, or SCAP, gives the consumer the option of going through an arbitration hearing rather than filing a lawsuit against the manufacturer of the car. The lemon law applies to all new cars purchased in Hawaii. The term new car also includes demos and a car which is transferred to a second buyer while the manufacturer's warranty is still in effect. Your car must be primarily used for personal, family, or household purposes, or be individually registered but used for business purposes and for personal, family, or household purposes, or be owned or leased by a business which has bought or leased no more than one car per year and is used for business as well as personal and household purposes. The lemon law does not cover mopeds, motorcycles, motor scooters, or trucks with a gross vehicle weight rating of over 10,000 pounds. Your car may be a lemon if it meets all of the following conditions. 1. It has a nonconformity. A nonconformity is a defect or condition which is covered by the manufacturer's warranty. 2. The nonconformity substantially impairs the use, market value, or safety of the car, making the car unfit, unreliable, or unsafe for normal use. 3. The nonconformity is not the result of an accident, abuse, neglect, or alteration of the car. And 4. You gave the manufacturer or its authorized dealership a reasonable opportunity to repair the nonconformity before the expiration of the lemon law rights period. The rights period expires 2 years after you took delivery of the car or the first 24,000 miles, whichever comes first. At this point, you have 1 year to file for arbitration with SCAP. Before filing for arbitration, you'll need to have given the manufacturer a reasonable opportunity to repair your car.
I bought my car 6 months ago, and the check air suspension light comes on whenever I go over small bumps in the road. It isn't a smooth ride, and the bottom of my car always scrapes driveways and speed bumps. I keep bringing my car in to be repaired for the same problem, and nothing is fixed. I want to know what you're going to do about it.
I'm really sorry you're having these problems with our car. I assure you it's an excellent model. Let me see what we can do to fix this problem, and I'll get back to you, okay?
Great. I'd appreciate that. Thank you. Goodbye.
Goodbye.
A reasonable opportunity is determined in one of 3 ways. First, the 3 times presumption, meaning you took your car in to repair the same nonconformity at least 3 times and the problem still exists. Second, the 1-time serious nonconformity presumption. This means you took your car in at least once to repair a serious nonconformity. The problem, however, still exists and is likely to cause death or serious bodily injury if you drive the car. And third, the 30 days presumption. Simply put, you repeatedly took your car in to repair the nonconformity, and the total number of days the car was in the shop totals 30 or more business days. Once you've given the dealership a reasonable opportunity to fix your car and the nonconformity still isn't fixed, send a letter by certified mail directly to the car manufacturer. Although not required by law, it's reasonable to give the manufacturer 10 to 14 days from the time the manufacturer receives your letter to fix the problem. Meanwhile, you must continue to make the required car payments. Failure to do so could result in repossession. This in turn may negatively affect your rights under the lemon law. If, after at least 14 days, your car still hasn't been properly fixed, fill out the Demand for Arbitration form and enclose 3 copies each of the following: your sales invoice, the warranty, repair orders, and your letter to the manufacturer. Also, include the $50 filing fee. This fee will be refunded to you if you win your case. Once you are notified in writing that your case is accepted for arbitration, a hearing is scheduled. The arbitrator's decision can be expected within 45 days from the time the case is accepted for arbitration. The manufacturer has a right to inspect and run diagnostic tests on your car prior to the hearing. You also have the right to review any test results before the hearing. However, no repairs should be made. Sometimes the manufacturer offers to settle the case before it goes to arbitration.
Hello, Mrs. Kealoha. Hi, this is John Barnett of the Meadowlands Corporation. How are you? Yes. Our service people have thoroughly checked out your car, and we are prepared to offer to buy back your car.
If this happens, you need to deal directly with the manufacturer regarding the terms of the settlement. Refer to the Lemon Law Handbook, which includes a sample refund calculation. You may want to get the terms in writing before you stop the arbitration process.
Thank you for offering to buy back my car. Could I have your offer in writing?
Absolutely. Now, after you've read and signed our settlement offer, we can mail your refund check to you in a couple of weeks, or you can pick the check up from the dealership when it's ready, okay?
Great, thank you.
You're welcome. I'll send you the settlement offer and we'll be in touch. Bye-bye.
Goodbye.
Should you choose to settle, you must notify the SCAP administrator. Your $50 filing fee defrays the costs of the arbitration program and will not be refunded. If you reject the manufacturer's settlement offer, a hearing is scheduled and your case will be assigned to a neutral arbitrator. Prepare your case ahead of time. Collect and organize all your evidence. For example, arrange all repair orders by date. List dates and amounts of payments and when the next payment is due. Include items such as invoices for towing, notarized statements from witnesses, diagrams, tape recordings, or videotapes. Let the SCAP administrator know before the hearing that you plan on presenting video or audio tape recordings so the proper equipment will be available at the hearing. You also need to arrange for witnesses. Prepare an outline of your case, including all relevant information. Prepare your response to the manufacturer's statement, which you'll receive ahead of time. And make a list of questions you want to ask the manufacturer. You also need to decide ahead of time if you want binding or non-binding arbitration. Binding arbitration means neither you nor the manufacturer may appeal the arbitrator's decision. Non-binding means either side may ask for an appeal in court within 30 days of the decision. If neither side appeals within 30 days, the arbitrator's decision becomes binding. The hearing generally lasts 2 to 4 hours. The arbitrator, who is a neutral third party, hears the evidence from both sides and makes a decision based solely on the evidence presented.
Good morning. This is SCAP case number 99127, Lani Kealoha versus Meadowlands Corporation. My name is Cynthia Nakamura and I am the arbitrator assigned to this matter. First, let me explain. Both parties will present all of their testimony and evidence today. No ruling will be made today, however. After I have reviewed all of the evidence and the testimony, I will issue a written decision which will be sent by certified mail to both of you. For the record, I see that Mrs. Lani Kealoha has chosen binding arbitration. Both Mrs. Kealoha and Mr. John Barnett, the manufacturer's representative, have signed the appropriate form. This means that neither one of you will be able to appeal my decision. Is that understood?
Yes.
Yes.
At this time, I will swear the parties and the witness in. Would you all please raise your right hands? Do you solemnly swear or affirm that the testimony you will give
Since the consumer is the one requesting arbitration, it is up to her
Yes.
to prove her case.
Mrs. Kealoha, please give your opening statement.
While driving my new car, the air suspension light has come on 3 times. Each time I took my car in to the dealership, the service people couldn't find the cause of the problem. However, the mechanic has replaced the sensor module twice. Although the light has not come on since the sensor module has been replaced, the bottom of my car scrapes driveways when I'm leaving, as well as whenever I go over speed bumps. I feel that this car is defective and that the manufacturer should be ordered to either replace or buy back my car and reimburse me for all transportation expenses incurred by me while my car has been in the shop.
Thank you. Mr. Barnett, would you like to give an opening statement for the manufacturer?
Yes, thank you. Although Meadowlands Corporation understands Mrs. Kealoha's frustrations, we do not believe that she's entitled to a refund under the Lemon Law. The dealership could not confirm the problem, but as a goodwill gesture, it replaced the sensor module. If the car did have a problem, it's been fixed, and the car is now operating as warranted.
The consumer now presents the evidence in her case, including the purchase or lease agreement, the warranty, repair orders, letter to the manufacturer, receipts for towing, rental car costs, taxi costs, and so forth.
Last year, I bought my car from the local dealership which sells the manufacturer's cars. You have the copy of my sales invoice and the rest of my documentation. 6 months after I bought the car, the air suspension light came on. I took the car in to be repaired and caught a taxi to work. Here's a copy of the taxi receipt.
Thank you.
At the end of the day, I went to pick up my car, and the service manager said that they couldn't duplicate the problem. 3 weeks later, the air suspension light came on again. Once again, I took my car in for repair. This is a copy of the repair order. This time, they replaced the sensor module. After that, I noticed that the ride was rougher and bumpier, and the bottom of my car was scraping against driveways and speed bumps whenever I passed over them. About a month later, the air suspension light goes on again. I took the car in to be fixed, and they again replaced the sensor module. I was so upset. I finally sent a certified letter with a return receipt to the manufacturer. Since I didn't hear anything from the company, I filed for arbitration.
Do you have any questions for Mrs. Kealoha?
Yes, I do. Thank you. Mrs. Kealoha, has the air suspension light come on since that last repair date?
Not yet.
Thank you.
All right, Mrs. Kealoha, you may call your witness.
Diane Fujimura is a friend of mine. Diane, would you please explain your experiences while riding in my car?
Every Thursday, Lonnie picks me up for our aerobics class. For the past couple of months, the car has been scraping the bottom whenever she exits a driveway or whenever she goes over a speed bump, even though Lonnie drives really slowly.
Thank you. Mr. Barnett, do you have any questions?
No questions, thank you.
Mr. Barnett, you may now present the case for the manufacturer.
Yes, thank you. The repair orders document the fact that Mrs. Kealoha's concerns could not be verified. Each time the car was inspected and test-driven, the car was found to be operating as warranted. As a gesture of goodwill, however, the sensor module was replaced. And hitting bottom when exiting driveways or when going over speed bumps does not necessarily indicate a problem with air suspension.
Mrs. Kealoha, do you have any questions?
Yes, I do. Mr. Barnett, what did you mean when you said it wouldn't necessarily indicate a problem?
Well, it could be the result of a person's driving habits. If a driver doesn't slow down to go over speed bumps or when exiting driveways, the car may scrape the bottom.
Mr. Barnett, assuming that the driver always brakes properly whenever exiting driveways and drives very slowly and cautiously over speed bumps, and the car still hits bottom, wouldn't that indicate an air suspension problem with the vehicle?
It could be a problem. However, more tests would have to be made.
Thank you. I have no other questions.
Mr. Barnett, I have a question. Would you please explain the purpose of air suspension?
Yes. The purpose of air suspension is, one, to provide a smooth ride through air shocks, and two, to keep the car level, for example, when you put a heavy load in the trunk.
Thank you. I'd like to call a recess at this time.
In most cases, at the conclusion of the testimony, a recess is called for an inspection and possible test ride of the vehicle. Following the break, the hearing resumes.
Before we have closing arguments, Mrs. Kealoha, for the record, would you like to state your observations of the inspection and test ride?
Yes. It was obvious when we went out of the parking lot, the bottom of my car scraped the driveway. The car also scraped bottom when we slowly drove over the speed bump.
Thank you. Mr. Barnett, you may state your observations of the inspection and test ride.
I observed that the car very slightly touched the bottom, and this certainly would not be considered to be a substantial impairment to the use, safety, or value of the car.
Thank you, Mrs. Kealoha. Your closing arguments, please.
Even though the air suspension light did not appear during today's test drive, I have shown that the car does have a suspension problem. The manufacturer has said it is an indication of a problem when it scrapes bottom like that when the driver is going slowly, and I most certainly was going slowly. I believe that this ongoing problem has in fact substantially impaired the use, safety, and value of my car. I asked Middlelands Corporation to buy back my car and reimburse me for all expenses incurred by me relating to this vehicle.
Thank you, Mrs. Kealoha. Mr. Barnett, your closing argument, please.
Thank you. Without a doubt, the Middlelands Corporation has proven today that the air suspension is operating as warranted. No one has been able to duplicate the alleged problem. And the slight scraping does not constitute a substantial impairment to the use, safety, or value of the car. Therefore, we steadfastly maintain that this car does not qualify for relief under the Hawaii Lemon Law.
Thank you, Mr. Barnett. Mrs. Kealoha, would you care to rebut Mr. Barnett's closing argument?
I just want to say that although the manufacturer acts like I'm being overly picky about this car, I know I'm not. I believe any reasonable person would also believe hitting bottom this way and the car's bumpy ride is a substantial impairment.
Thank you all for participating. You may expect my decision within 45 days of the time the case was first initiated. This hearing is now closed. No further evidence will be taken on this matter.
The arbitrator in this case saw that the bottom of the consumer's vehicle scraped the driveway while it was exiting. The car also scraped bottom while going over speed bumps and sent out loud grinding noises. Now, based on the evidence, the arbitrator found that the defect with the vehicle's suspension substantially affected the use and market value of the car and was not the result of consumer abuse. The consumer received a full refund for her purchase price, less the mileage she put on the car, and she was also reimbursed for transportation costs. Once the decision is made, it is sent to both you and the manufacturer by certified mail. If you would like more information or a copy of the Hawaii Lemon Law Consumer Handbook, please write to the Consumer Resource Center, Department of Commerce and Consumer Affairs, Post Office Box 2399, Honolulu, Hawaii 96804, or call area code 808-587-3222.